Today, we're going to talk about what are the obligations of family dispute resolution practitioners and go through in a little bit more detail on some of the areas. As always with our webinars, if you've got questions or comments, just turn your mic on, put your hand up or whatever, and we can pause and have a little bit deeper look. Before I go any further, I'd like to acknowledge Aboriginal and Torres Strait Islander people as the traditional custodians of Australia and pay my respects to elders past, present and emerging. I really think it's important to recognise the continuing connection to land, waters and culture. And I come to you today from the lands of the Gunai Kurnai people in Gippsland in Victoria. For anyone who doesn't know me, I'm Joanne Law, Director of Mediation Institute, and I'm a family dispute resolution practitioner and train our grad dip in FDR course. What I've got planned is looking a little bit about the framework that we work within, our obligations, our ethical obligations, and maybe we can talk about a few of the sorts of issues that we face in this work that we do. A little bit about how we remain current, and if we've got time we can talk about some questions or scenarios. So according to Section 10F of the Family Law Act, FDR is broadly defined as any non-judicial process where the independent family dispute resolution practitioners assist people affected by separation or divorce to resolve some or all of their disputes with each other. We work within the full range of the issues that people may have when they separate or divorce. So even if your property settlements isn't your favourite thing, it's important that you have a good enough understanding to be able to support people or refer them or help to make sure that information provided is appropriate. One of the best sources of information, I suppose, collated and pre-digested a little bit for us are the information sheets that the Attorney General's Department puts out. Some of them were updated with the amendments to the Family Law Act in May of this year. So if you haven't looked at them since May, then you haven't looked at the most recent versions. Family Law, Family Dispute Resolution Practitioners Regulations 2008 are the specific regulations that we work under, as well as various parts of the Family Law Act and the Family Court Act of WA, which mainly mirrors the Family Law Act these days. But it is separate legislation and it is a separate court to the Federal Circuit and Family Court of Australia. So as more and more of us are working online, we're working with clients all over the place. It's really important that we are aware of the legislative framework and also the other legislation that applies, so family violence legislation, and that's going through updates and changes primarily as coercive control and non-physical violence becomes much more sanctioned. So that it's not coercively controlling someone, limiting their choices, financial abuse and all of those sorts of things are factors both at the state and federal level. Child support, again, we need to have a working knowledge. We need to not just dodge the question if issues arise around child support. We need to understand privacy legislation so that we know what's private and confidential information and what isn't. And just a reminder that the Family Dispute Resolution Practitioner regulations are sunsetting and they don't have the option of any further extension. So there will be a new version of the regs coming out by 1st of April next year. So the Attorney General's Department had indicated that they'll be doing some keep your eyes out for opportunities there to engage with our regulators. And just having a look at the chat. So with Elizabeth, with workplace mediation, we don't have a specific legislation in Australia for mediation. Some countries do, but what we do have are the national accreditation standards. We're in the transition now from a system to standards. So we had the national mediator accreditation system.
Yeah, now it's en masse. Yeah, so
yeah, and now
I'm not really aware of any obligations from legislation for workplace mediators, but I'm not an FDRP, but I'm curious what they have because I know that they have some mandatory reporting. So it's just to increase my awareness for other mediators what obligations there are.
Yeah, absolutely.
Yeah.
And welcome. And look, there are some crossovers, certainly in the duty of care type areas where, and we'll talk about that a little bit more in the confidentiality sort of concerns.
Mhm.
So again, just pop your hand up if there is something that you want to stop and help. With family dispute resolution, I guess one of the things I wanted to raise is that we're really, the family is our client. As FDRPs, unlike lawyers or others that might be working individually, we're hearing both sides of the story. We may, some of the more innovative approaches are working with wider family groups as well, and the child inclusive processes as well. So we're really looking at, we have obligations to everyone in the family, whether they're present in the room with us or not. And as those that are FDRPs will know, that the updates on the best interest of the child have really brought that focus about their needs and their best interest in terms of their developmental and safety and relationship requirements. And of course, we've got obligations around duty of disclosure and fair and equitable in the property regime. So with regards to our specific legislation, the main regulations that we need to really look at are regs 25, 28, 29 and 30. And they relate to a range of things from providing legal advice, confidentiality and disclosure obligations, the inadmissibility of communications in family dispute resolution, and the inadmissibility protections that FDR practitioners have, screening, and the absolute obligation that we have to not proceed if it's not going to be suitable, if people aren't freely able to make decisions. Impartiality, not taking sides, and again that comes into our ethical obligations as well. Informed consent. So these are some of the things that I thought we might look at a little bit more deeply. Explaining the process to parties so that it is informed consent, our obligations around Section 60I and certificates, conflict of interests when they are potentially arising. And of course, we've also got an obligation to provide information about our qualifications as family dispute resolution practitioners and how people can make complaints. And that's mirrored in the MDRAS and NMAS regulations for nationally accredited mediators as well, that we have to provide information about how people can make a complaint if they're not satisfied with our services. And fees, including your hourly rate, is also something that's mentioned in the regulations. So I guess I really want to remind people that when we're thinking about creating innovative services and one-stop shops and set fee for services, we still need to be making sure that we're not breaching our obligations around conflicts of interest and information that's being provided about the services. For those that don't know, one of the roles that I do is heading the complaint handling services provided by Mediation Institute. So I get to hear the sorts of things that people feel upset about and want to make complaints about. With regards to providing information, we've got an obligation to avoid giving legal advice if you're not a practicing lawyer and clients agree to you providing advice. But even if you are a practicing lawyer, you've really got to think about your obligations as a legal practitioner and providing legal advice to people who are in conflict. So most lawyers still steer well clear of providing anything that could be considered specific tailored legal advice or strategic legal advice, and stick to providing legal information or general advice for their own protection and for the protection of clients, because it's very difficult to maintain a position of being seen as unbiased if you're providing advice that's going to favour one party more than another. So it's, in most cases, even if you are legally qualified, it's a really good idea to refer people to specific legal advice. But we do need to provide information. So part of the obligations of family dispute resolution practitioners is to provide really good quality information to clients about the family law system, about the meaning of the best interest of the child, and if necessary about the changes, because people may have been receiving information or advice over a period of time and be stuck on old definitions and rights. We have an obligation to provide people with information about the impacts of family violence on children, so that they can understand the real importance of helping to protect children and keep them safe from exposure to family violence or being victims of. And referrals to resources that could assist clients, which might include legal advice, support, other services. So part of the process that we must do, or we must know has happened, is screening for risk, for suitability, for vulnerabilities and other issues that may impact people's ability to participate freely in family dispute resolution. So we are practitioners that really do need to rely quite heavily on referrals if we are going to help clients to make the most of the supports that are out there. And also another area is with parenting plans, that the information has changed, and if you've been away from things for a little while and haven't kept your information up to date, so if you haven't made a major overhaul since the May amendments, it's time to have a look at that as well. And also our obligations regarding duty of disclosure and making sure that clients are fully aware of that. And the final dot point there is how to make agreements legally binding. So we need to be able to talk to people about the relative status of parenting agreements, parenting plans, parenting orders, consent orders, and so on. So quite a lot of information. It used to be that you'd provide a big information booklet or something like that. It seems that we've got a trend to people accessing information much more on mobile phones, much less likely to actually read large amounts of information. So thinking about how are you getting all of that information across in a practical way. One of the important parts of our role is having a very clear idea of the context of the family law system and all of the different roles. So family counselling. So sometimes people will reach agreement around parenting, particularly in family counselling, and just work with an agreement that they've reached in that way. Family dispute resolution, their first entrance to the sector may be through the family violence court in their state or territory. And family court, of course, often negotiations might be done either by shuttle, where the people aren't directly communicating in an FDR context, or lawyer facilitated negotiation. So again, in the middle there where there's not that direct communication. Arbitration, very little use of arbitration in this context still in Australia, but it is available for property matters, and referring to a family law arbitrator if there's points of contention on factual issues might be a speedy and slightly more cost-effective way for people. And a lot of people, they fall out of the system or never enter it, and they just continue on with unresolved conflict or just disconnect. So someone's lost to the family. What have I got there? We're not all doom and gloom. Sometimes people can just get together and negotiate things themselves. Sometimes there's a need to help people to look at where's the next step if they get, say, mediation is not agreed to by a party. Yes, we can provide a Section 60I certificate, but it's also important for them to know that they don't necessarily have to go straight to court. They could try some lawyer facilitated negotiation or other options. Any thoughts on that? Is there anything I've missed?
I just wanted to say that sometimes, and as a lawyer and as a mediator, I've had situations where I or someone has issued a Section 60I, and it's amazing, the person who's been evading the situation will suddenly go, oh no, I'll do mediation, because they don't want to go to court. I say to them when I'm issuing it, sometimes just getting the certificate will actually make them see the light and take mediation as an option.
Yeah.
But it is a bit sad. I've had a couple lately where I've had to issue certificates and I've thought, I had what Valley Tolpan calls the Vicar of Dibley matter. We had yes, yes, and then 15 minutes before the end, she said no. So frustrating.
Yes. Yeah, I had one not too dissimilar recently as well. So yeah, that's definitely one of the factors that can happen, and they might realise that they're standing at the edge of a cliff, that they need to throw a lot of money down and decide that maybe they'll have another go. Another really common dilemma that we face is where we contact the second party and they say, oh, I can't afford your services, I need to go somewhere else, particularly for private practitioners. And then we've got that dilemma of deciding, do we issue a certificate? Do we think that's genuine? I had a conversation with someone one of our members called up and had a conversation about that fairly recently. And the answer is, we ultimately have decision-making power as a registered family dispute resolution practitioner. It's really up to your judgment to really think about what are the consequences of issuing, of not issuing. But it doesn't, if you do issue a certificate, it doesn't mean they have to go to court. If the other person is genuine that they are wanting to mediate, they just can't afford your fees, then they'll immediately be able to go and initiate the process with a service that's more affordable for them. And if the other one agrees, then that's great. If they don't, then the Section 60I certificates will tend to cancel each other out. The negative consequences of refusal are less likely to be a concern if they do end up in the court. I said a lot of stuff there that's assuming that you all understand those, and I'm going to talk about the Section 60Is in a little bit more detail. However, often in that situation, the person is legally represented. It's apparent that they do work and they do have funds. And as an FDRP, we might decide that it's actually a delaying tactic, that they're just trying to, I suppose, delay the inevitable. And a certificate might help to focus their attention. Any other thoughts about any of those options? Next bit I was going to talk about is our confidentiality obligations. So it's very explicit in the Family Law Act that we're not to disclose any communication made during FDR unless it's authorised or required under the Act. So we are mandatory reporters. We have to comply with that legislation related to child safety. So if we do feel that there's a risk of harm or neglect, we must contact the local child protection agency that's relevant for where that particular child lives. And sometimes that can be a bit of a scary thought for practitioners, but remember, all we're doing is a report. It's up to the agency to consider how that fits into context and what action they're going to take. Often it may just be, in some ways, a bit of a debrief and discussion that you have with the person on the other end of the phone. If you do make a mandatory report, it's really important that you keep a file note about when and why and what were the concerns objectively that prompted you to make that report. There is a very slight chance that the inadmissibility provisions would be waived if you were the only person who had information about a risk to a child and it ended up in court. It's highly unlikely that you would be, as it's often one of the parents that's making a disclosure anyway. But I don't think I've got anything on the particular slides, but there's a bit of a myth that goes around that as mediators or FDRPs that we just destroy all of our documents after the mediation. That would be very bad advice. We should be keeping a file on our cases and certainly be keeping a file note if there's anything untoward happens. If you do end up getting a complaint, and it might be a complaint because you won't issue a Section 60I certificate because you don't consider that the matters they want to come back are the same as you had when they mediated, all of that, you're really not going to be able to do your job properly if you don't have any records or files related to the people that you've worked with. And feel free either to use the chat or to join the conversation if you have any questions or thoughts about that holding on of information. We also may disclose offences relating to physical or psychological harm, threats of harm, serious or imminent threats to life or health, or preventing or lessening a serious threat to property. The same applies under the national accreditation standards for mediators. We have a duty of care. So if we're told something that makes us think that someone is at risk of harm, even if it is harm to themselves, then we do have a moral, ethical, and at times legal obligation to try and help to prevent that happening. I had put a question to the Attorney General's Department. I haven't had a response yet. Sometimes they take quite a while to think about things. About with the increasing changes regarding coercive controlling behaviour and criminalising that, we often have that type of behaviour disclosed to us in family dispute resolutions. It's interesting to think about where do our obligations fall there in terms of reporting that type of behaviour. If anyone's had any experiences or any thoughts about that, feel free to share. Yep.
No, I don't have an experience of that. But so firstly, does it say in the Act where that would need to be reported to?
No, it's not specific. So mandatory reporting, that's quite clear. It's to the specified child protection agency. But with other threats, it may be that we just notify the person that the threat's been made against, or it may be we contact the police. So it probably depends on the context.
Yeah, and I'm interested how you say it applies to in mass mediators as well. For workplace mediation, in my agreement, I say that I can disclose if there's if I have a serious concern about their health or being or safety.
Yeah.
And so I explain that to them so that because I'm hired by their employer, so I would tell their employer, for example, if they said they were suicidal or something like that, or had been feeling suicidal at the time of the incident or something like that.
Yeah, absolutely. And that's putting it in the agreement, like being really clear up front for people is, I think, a really important part of this whole piece around confidentiality. We have an obligation to tell people what the framework is that they're entering into before they make disclosures. We hope that won't prevent someone making a disclosure about being suicidal particularly, but yeah, it's important that's part of the upfront information provided. So yeah, it sounds like you're doing the right thing there, Elizabeth.
Thanks.
The other exemption in family dispute resolution is if we're required to disclose information to assist an independent children's lawyer. I don't think that happens very often, but potentially it may be happening. It's more likely if it's been court-ordered mediation, so they're already in court and an ICL's been appointed. We're always able to disclose information with the permission of the person who's disclosed it. The Family Law Act specifies that if the disclosure is by a child under 18, it needs to be with the permission of both parents, but that's not related to safety issues. So you don't, for example, if a child disclosed that they were being abused by a parent, you don't have to get the parent's permission to make a report or to seek support for them. So it's that non-duty of care mandatory reporting information that we need permission. And that relates specifically to child inclusive practice, where we usually refer to another experienced practitioner who will meet with the children, or in some models where the FDRP will meet directly with the children. That's normally done with an agreement with the parents confirming their permission for that process to occur. And then within the process, there's also an agreement with the child or young person that they get to say what information is going to be shared with their parents when the information sharing stage of the process happens.
Joanne, just on that, I either act as the child consultant or the mediator.
Yeah.
I'm just interested that you said that it can happen did I hear you right, that the mediator might actually meet with the children? Such an unregulated area, but I'm very clear about the boundaries that I have. Is there nothing that actually prevents that. So if I'm struggling for a child practitioner to assist me as the FDRP, is there actually nothing that, is it just part of the non-regulation of this area?
Yeah, it's just part of the non-regulation. So as long as you've got a working with children check in the state or territory where the young person is, then you're not prevented. John Graham, that's the model that he has, and he's been doing a fair bit of training with some of the agencies and services. So it is a model that's being used around. I do think it has some challenges. I guess the similar sort of challenges that you have if someone's providing legal advice to the parents. It's difficult to have that totally independent third-party position when you're also sharing things that one or both parents might not like that's been filtered through from their child. Yeah.
Thank you. It's not ever, and I know when I did my training, it was years ago, I was thinking it was a bit frowned on, but I wouldn't do it. I would be really
look, it's not, it is a little bit frowned on, but it's not prohibited. And I've had conversations with the Attorney General's Department and the Practitioner Registration Unit people about it. But yeah, there are some concerns around the roles and the lack of role clarity that can occur, but it can also be quite relevant. There's a number of people and organisations that are using a much more of a family conferencing model now as well, where extended family might be present, the child might be present, cousins and what have you, but it's within the family law context. So there's some innovation and some changes happening, but we always need to come back to what are our obligations. And again, with that family group conference style model, there's nothing prohibiting that, because remember, the definition of family dispute resolution is very broad in the Family Law Act. It's any non-judicial process that's facilitated by a family dispute resolution practitioner helping people to sort out issues related to separation. Yeah. And again, under the legislation and conventions that we're signatories to, children have a right to express an opinion about issues that concern them, and separation and divorce with their parents and arrangements for their living conditions is certainly something that concerns them. So, yeah, it fits within the framework. We are also able to provide information for researchers, but it should be not personal information as defined by the Privacy Act. So if you are engaging with researchers and you're not sure what information you can or can't give, it's probably a good idea to read Section 6 of the Privacy Act just to refresh yourself about where the lines are. And we should be cleaning up the information, a printout of your client list or something, which I'm sure people wouldn't be doing, but anyway. And within your practitioner organisation, nothing specifically says that, but to make things functional. And I usually encourage you to make sure people understand that information may be seen by other people working in your organisation if you're not a sole practitioner, or I don't know, if you've got a call answering service or something like that. So the other area is inadmissibility. Again, we have protection under the legislation, which isn't the case for nationally accredited mediators. The protections there are under common law and convention, unless there's a specific context where you're working. And so it's important to have your agreement to mediate that people sign to say that they're not going to seek to make use of any information from the mediation. And I still encourage you to do that as well, even if you are working in the FDR realm, because we've got a little bit of uncertainty about where FDR actually starts, and so whether the pre-mediation stage is protected by inadmissibility or not. So, yeah, I recommend it's a good idea to get your agreement to mediate signed as soon as you can in the process, and make it clear that nothing should be used or attempted to be used in a court. And that avoids the risk of subpoenas, hopefully. And of course, if people do reach agreement and they develop a parenting plan, that will be admissible. And in fact, it must be considered by the court. The most recent parenting plan must be considered. How it's considered, that's up to the judge or registrar. Again, if you, like me, believe that because pre-mediation's mandatory, that it's part of the FDR process. You could challenge a subpoena if one was made to request information, but you must comply with the court. You don't just ignore it. And if you do get one, that you can, if you go to the Federal Circuit and Family Court of Australia or the Family Court of Dublin, there will be more information about the process to challenge one. And the reason I say we've got the uncertainty is the Rastel and Ball case in 2010, where a magistrate thought that FDR doesn't start until the actual mediation starts. So important to explain to people about that, and also our role to be impartial, which might be regarded as being unbiased or free from favouritism and prejudice. I did a session on reflective practice recently, and that's something that we need to be all participating in and really making sure, because we come through life developing biases and assumptions and all sorts of things. And so as FDRPs, we have to work really hard to try and make sure that those don't creep into our work without us noticing, and that we are able to facilitate free from favouritism or against unconscious bias against someone who doesn't share our values or whatever. Neutrality is often challenged in the concept of mediation, because how we're in there to create an intervention, how can we be neutral? But often the context, it means that we're able to be objective, providing the opportunity for multiple viewpoints to be considered, and again, avoiding the bias in the way that we facilitate the process. Sometimes I might get a complaint because the mediator has, according to the complainant, allowed one side to have almost unlimited time and free air, and they felt like they were squeezed out and weren't able to appropriately express themselves. So managing, sometimes we've got to be a little bit of an intersection police person and manage the flow of information as well. It's very much about that. However, there are issues regarding equity as well, which mean that sometimes we do need to provide some additional support, or allow someone who talks more slowly a little bit more time, or someone who needs more explanation. That opportunity particularly can be really difficult in shuttle, because you're going along well, you're watching the clock, and then something big comes out. If those sorts of things happen, probably a good strategy is to raise it, verbalise it, give meaning about why there might have been an imbalance or something like that. What do others think? Is that something that you just ignore it and hope no one notices? Or, yep, Verity?
Yes, I think it's a really important part of mediation, and that is one of the skills that you have to be on top of, because it's so easy I haven't had a complaint so far, but it's about explaining it, because it does happen whereby you spend time with a party who is just a bit slower, has issues. And if everyone knows why it's all happening, if they understand the process, then you're impartial. You create your own impartiality.
Yeah, absolutely. Yeah. And it's really around that, being clear with people what's going on. Very much so. We really, I guess we can be transparent about our process. Ideally, we're explaining to people our style of mediation, how we work, provide that information to people up front. We need to follow it. And then if there's detours, we need to explain why that's happened, has to happen. Again, we've been through this many times. Assessing of suitability, it's not about whether or not there's been family violence. It's about how it may impact the ability of any party to negotiate freely. And I think pretty much anyone who's been in the FDR field for a while has noticed that we're getting a lot more higher conflict cases. I think in part it's to do with people are still a bit upset after COVID and all of that, but it's also the change in the courts that are not accepting lawyers just writing an exemption and straight into court. I was looking at an old presentation I did in 2019, and it said about 50% of matters were going straight to court. parenting matters, it's much, much less than that now. So there has been a shift, but it also has meant that we're getting more higher conflict sort of cases, and we have to really look at the ability for us to provide a process where people can negotiate freely. My advice or my approach is always to talk about it with the parties, particularly if we think someone is vulnerable and may be subject to coercion, either because of their conflict style or because of whatever elements in the situation. But also we need to think about the reality is that often someone does hold a position of power, whether that's that they've got the child's fully with them and the other person's begging for time, or it might be that they're in a more comfortable financial position and the other person is perhaps feeling like they're begging for scraps. This is a hard part of our work, and something that it can be very useful to talk with colleagues about and just talk through. And again, just a note to the gendered nature of family violence. We know that statistically it's more likely that it may be violence perpetrated by a man against a woman, but if we're working with one family, and statistics don't count, we need to be very thorough in our evaluation of exactly what's going on in that situation as much as we can, and not working based on assumptions. We need to be working based on the information that we're able to get. And of course, it's often quite conflicting and not clear, but we need to come back to our obligation. Is the situation unsafe? Do we need to make reports? Do we need to take some action for someone to be safer? Do we need to make referrals so that they have support? Or do we need to decide that it's not appropriate? So all of those things are parts of our obligations. And of course, I'll just put a point there is sometimes if we focus too deeply on the best interests of the child, the parents can feel really unheard and really like you're not working with the family, you're just working with the child. But ultimately, the child needs parents, someone who's looking after them and caring for them. At mediation, we really need to be working with that whole family to try and make a process that's going to be fair and arrangements that are going to work. And I just shared the Duluth equality wheel just because wouldn't that be nice if all of our clients were like that? Any thoughts about this? This might be a little controversial. If it's pressing your buttons, let me know. Violence, understanding the impact of behaviour and particularly coercive behaviour is a really important part of our role. Just with parenting plans, again, written, signed, dated, and free from any threat, duress, or coercion is what makes a parenting plan. Section 60 of the Family Law Act outlines some of the matters that it may address. And remember, a fair part of this section has changed around parental responsibility and so on. If you haven't been on top of the changes, it's a good area to review as well. Parenting plans can address child maintenance issues. It's more often related to the incidental costs, sporting activities or other extracurricular activities, sharing costs of education, travel, all of those sorts of things might be specified. And it's good practice to talk with parents about a dispute resolution clause, what to do if they don't agree with something. I guess that in that regard, our role, but even if you're nationally accredited mediator, we're not just a scribe. Part of our role is helping people to get plans and agreements that really look at contingencies and what would happen if, and reality testing, to try and help them to get an agreement, because we've got a lot more context and perspective that may help to identify areas. We've done or we do whole sessions on Section 60Is. They tend to be the area of most discussions, and I talked a little bit about that before. But if we are going to issue a certificate saying that someone has refused to attend or someone didn't make a genuine effort, it's really important that we are very scrupulous in making sure that we've contacted them at least twice, once in writing, that we've explained the consequences of refusal. And just a note for anyone that is working in WA, they do have a different certificate that relates to Section 60I and Section 66H of the Family Law Act WA, and you can download a fact sheet and the certificates from the AG's site. Just, I'm aware of time, so these are more really summary type things, and I've mentioned about collaboration and referrals. In the grad dip, one of the expectations is that we are continuing to contributing to improvement in practices and processes, but also we have a positive obligation to make sure that we are up to date with changes in the law and regulations and so on. So it's not, as a registered family dispute resolution practitioner, it's your obligation. It's not boss or manager or anyone like that. It's you've got a proactive obligation. And so the regulations, so 24 hours, 25 hours for national accreditation of education, training, professional development. Your professional association may ask for evidence when you renew. The Attorney General's Department does audits, and if you can't provide evidence, you may be deregistered. They did a big cull a few years ago, a number of practitioners that had just not been doing anything. And what they use OPD in the terminology, you can't count just working as professional development. You'd need to, if you're participating as a client in role plays, you'd need to demonstrate how it develops your own practice. So maybe do a reflective journal entry after a role play so that you're able to, this is when I did it, this is the thing, and this is what I learned or what I realised. And for your FDR, professional development, things like doing first aid courses wouldn't be considered as ongoing professional development. So it's very much focused on this role. Because as we've seen from this very brief presentation, there's actually a lot we need to know. Just about finished up. One thing I do want to let you know, we've finally launched our new members portal, mimembers.au. So anyone here who's a member, you'll be able to log in now. Just use your email address that you've given us to register for your membership communication, and you need to do the password reset to verify your email address, and then you'll be able to log in. Any students, you'd need to click on join, and then we'll verify that you're a student, and then you'll have full professional development access. And we've introduced a new category of members for those that don't need practitioner membership benefits of complaint handling and directory and things like that, but who'd like to be members and access free for members professional development. Very exciting. It's supposed to launch on the 1st of July. It's the 23rd, and we just did over the weekend. It's got an events area where you'll be able to register, and when you register and attend events, they'll go straight into a professional development record that you'll be able to keep, and you'll be able to keep track of practice hours as well. For any of your mediation work, you might want to maybe do a monthly log or something like that, because certainly if you're nationally accredited, you'll be hopefully aware that there's going to be different levels of national accreditation based on years of experience and practice hours. It's important that you are logging your work, not identifying client information or anything like that, just in a way that you're able to know what it was and provide evidence of if needed. And that's all. So sorry I rushed through a little bit and have gone over, but any final thoughts, comments, questions about the obligations? Thank you for watching this webinar recording. You can participate live in our online events by joining Mediation Institute. Go to www.mimembers.au to find out more or to see what events we have coming up. Remember to like and subscribe to be notified when more videos are uploaded.